Can the 25th Amendment be used to remove President Trump? Let's find out. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today's lecture, ladies and gentlemen, we'll be discussing the possibility, rather the legality, the basis upon which something like the 25th Amendment can be invoked in order to remove current sitting U.S. President Trump, President Donald J. Trump. We're going to go over the 25th Amendment. We're going to go over Article 2, which outlines the powers of the U.S. President, Article 2 of the U.S. Constitution. I'm going to show you in the Federalist Papers exactly what's going on here and a mode that would be more conducive to the results that are being sought. So first, let's go over the most important document, the U.S. Constitution. So we'll discuss Article 2 very quickly, go to Amendment 25, and then we're going to dive into the Federalist Papers, Anti-Federalist Papers, and then I'm going to provide a couple avenues, a few options that can bring about the same result, but in a faster, equally constitutional basis, so that way any further transgressions can hopefully be prevented, evaded, whatever you like to call it. So, Article 2 in the U.S. Constitution, the one detailing and forming the executive department. Section 1 says the executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President, and if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. But in choosing the President, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. Oh, that was the end of the sentence. The Vice President. The Congress may determine the time of choosing the electors and a day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. In case of the removal of the President from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed, or a President shall be elected. So even before the 25th Amendment, they already had a list of successors. 25th Amendment did not need to be added. And that gives the same powers to the Congress to remove the President. The President shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. Quote, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. Section 2. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states. Important caveat here. When called into the actual service of the United States. Who calls the service? The U.S. Congress. The U.S. Congress is the only branch of the U.S. government that can declare war. That's in Article 1, Section 8. I think it's Clause 11. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court. Notice they say judges, not justices of the Supreme Court. Judges of the Supreme Court and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone in the courts of law or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. Recommend, not require, not compel. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. In Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of. So just impeaching them is like an indictment. It's not a conviction of the crime. It's an observation of probable cause that something criminal has taken place. So they have to be impeached and convicted of treason, bribery, or other high crimes and misdemeanors. Okay, so let's skip on down to Amendment 25. So there's already one mode that we can take up besides Amendment 25, impeachment. Amendment 25, ratified in 1967, says this. Section 1, in case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Why did that need to be added? That was already in Section 2, or Article 2, excuse me. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. So the President can actually surrender the powers, the Vice President assumes the powers, and until the President says, oh wait, never mind, I'm doing okay, the Vice President gets to keep those powers. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration, because the departments are created under the executive. Remember that in Article 2, I think it was Section 1. The departments are part of the executive. So if they submit a declaration as to the inability of the President, their word is just as binding as the President's word, because he ultimately created that department. Transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. The Vice President shall immediately assume the powers and duties of the office as acting President. So the moment the letter is received, the declaration is received from the departments, the Vice President assumes the power of President, assumes the position of President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. So even if the President comes back and says, no, their written declarations are illegitimate, if the Vice President and a majority of the principal officers of the executive departments come back and say, actually, no, the president's declaration is untrue, they can act as kind of a veto of the president. And the president's declaration saying that there is no inability existent. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the president is unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of his office. This process is significantly more complex. Well, I guess not significantly. It is a substantial bit more complex and difficult to complete and fulfill than the impeachment process. But there are other modes to go about setting these supposed transgressions straight without basically making the punishment moot, because the transgressions will have already taken place by the time this procedure is fulfilled. Before we get to those other modes, I do want to go ahead and address this point directly, because I can already hear the clattering in my ear from Trump supporters. Well, Trump can do this because he's the executive, and we need to go over there and we need to do stuff in the Middle East, this, that, and the other. And they're making finally this recognition that what's happening and taking place in Iran is actually a war, even though just a month ago they didn't want to call it a war, because then that would require Congress to make a formal declaration and then approve sequentially the steps that were taken during the Iran war. I do want to show you from the Federalist Papers, a part of a collection of very significant papers pertaining to the history and the meanings of the U.S. Constitution. In Federalist Paper 67, written by Mr. Alexander Hamilton, so this would be the individual the founder who would be most likely to be in favor of that position, that the executive can go and unilaterally do all of these actions in a foreign land, in a foreign nation, without first getting approval from Congress. Here's what he says is the executive department, and he says it in a few different papers. So, written by Mr. Alexander Hamilton, the New York Packet, on Tuesday, March 11th, 1788. He says here, and please go read this full document for yourself, just so that way there's no concerns about misinterpretation or mischaracterization. The only reason I'm only reading the highlighting parts is because I'm going to try to my best to keep this lecture underneath an hour, so that way it's more easily digestible. He says, here the writers against the Constitution, so he's referring to the Anti-Federalist Papers, which we're also going to go over. Here the writers against the Constitution seem to have taken pains to signalize their talent of misrepresentation. Calculating upon the aversion of the people to monarchy, they have endeavored to enlist all their jealousies and apprehensions in opposition to the intended President of the United States, not merely as the embryo, but as the full-grown progeny of that detested parent. So foolish it is as an anti-federalist, to think the President would ever be viewed as a king, would ever be viewed in this supreme authority. To establish the pretended affinity, they have not scrupled to draw resources even from the regions of fiction. The authorities of a magistrate, in few instances greater, in some instances less, than those of a governor of New York. Do you think the governor of New York, according to Alexander Hamilton, is equal or even superior in some aspects to the U.S. president? That's what Hamilton is saying. The U.S. president is no more powerful in some regards than the governor of New York. New York had been magnified into more than royal prerogatives. He has been decorated with attributes superior in dignity and splendor to those of a king of Great Britain. He has been shown to us with the diadem sparkling on his brow and the imperial purple flowing in his train. He has been seated on a throne surrounded with minions and mistresses, giving audience to the envoys of foreign potentates in all the supercilious pomp of majesty. The images of Asiatic despotism and voluptuousness have scarcely been wanting to crown the exaggerated scene. Exaggerated scene. We have been taught to tremble at the terrific visages of murdering Janissaries, to blush at the unveiled mysteries of a futile seraglio. Scroll down a little bit further. I think I highlighted another section in this paper. Oh, I guess not. So we'll go on to Federalist Paper number 69. And you're welcome to read number 68. It mainly talks about how the president's to be elected. Number 69 is where we really discuss exactly what the executive is supposed to be doing, the purpose of the executive. And remember, Did anywhere in Article 2 say the president can go and bomb a foreign nation without congressional approval? No. And it doesn't matter whatever act you want to cite, War Powers Act, it doesn't matter. We've already gone over this in a previous lecture that George Washington, the first commander-in-chief, so if there's any man to appeal to in terms of opinions and beliefs about the powers of the executive, it would probably be him. He said any offensive action, such as kidnapping the leader of a foreign nation, such as killing, 50 plus of the foreign leaders of another nation, bombing another nation's nuclear facilities, whatever you want to call it, or whatever event that has taken place, whichever one you want to discuss, it's considered an offensive act, which George Washington said very clearly and directly cannot be undertaken without first getting the approval of the U.S. Congress. That's the first commander-in-chief saying that. How about Mr. Hamilton, the person who would be most in favor, the person who said, almost verbatim, that the reason he wanted Washington to be the first president is because he would be the most convincing individual for making the executive into a king. That's why he wanted Washington to run for a third, fourth, fifth, infinite number of terms, because Washington, according to Hamilton, was the only man worthy of that title. It would be the most compelling case to extend the powers of the executive beyond their constitutional limits. But here's what Hamilton says in number 69, the real character of the executive. March 14, 1788. I proceed now to trace the real characters of the proposed executives, as they are marked out in the plan of the convention. This will serve to place in a strong light the unfairness of the representations which have been made in regard to it. So it's unfair to say that the president would ever have more power than the governor of New York. It's unfair to say that the U.S. president would have more power than the U.S. Congress, would have more power than the U.S. judiciary, would have more power over the states than the states having checks against the executive. The first thing which strikes our attention is that the executive authority, with few exceptions, is to be vested in a single magistrate. This will scarcely, however, be considered as a point upon which any comparison can be grounded, for if in this particular there be a resemblance of the king, or to the king of Great Britain, there is not less a resemblance to the Grand Seigneur, to the Khan of Tartary, to the man of the Seven Mountains, or to the governor of New York. That magistrate, the president, is to be elected for 4 years and is to be re-eligible as often as the people of the United States shall think him worthy of their confidence. In these circumstances, there is a total dissimilitude between him and a king of Great Britain, who is an hereditary monarch possessing the crown as a patrimony descendable to his heirs forever. But there is a close analogy between him and a governor of New York, who is elected for 3 years and is re-eligible without limitation or intermission. If we consider how much less time would be requisite for establishing a dangerous influence in a single state than for establishing a like influence throughout the United States, we must conclude that a duration of 4 years for the chief magistrate of the Union is a degree of permanency far less to be dreaded in that office than a duration of 3 years for a corresponding office in a single state. The President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes and misdemeanors, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. In this delicate and important circumstance of personal responsibility, the President of Confederated America would stand upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware. So in fact, the governors of these different states had more power than the U.S. President. The President is to be the Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. And again, who gets to determine that call, when that call is made, and further how it's made? The U.S. Congress, Article 1, Section 8. He is to have power to grant reprieves and pardons, to recommend to the consideration of Congress such measures as he shall judge necessary and expedient, to recommend, not require, not compel, not demand, not legislate, recommend. To take care that the laws be faithfully executed. To commission all officers of the United States. First, the President will have only the occasional command of such part of the militia of the nation as by legislative provision may be called into the actual service of the Union. So just in case Article 1, Section 8 didn't make it clear enough, here is Alexander Hamilton, who wanted a king in the U.S., saying, actually, no, sure, the president gets to have the sword, but he doesn't get to wield it. He doesn't get to unsheath it without first getting permission for every single second from the legislature. Further, he says, while that of the British king extends to the declaring of war and to the raising and regulating of fleets and armies, all which, by the Constitution under consideration, would appertain to the legislature. Again, the president may possess the sword, but he doesn't get to unsheath it even a millimeter without first getting permission from the U.S. Congress. The president is to have power with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. Further, the president is to nominate, and with the advice and consent of the Senate, to appoint ambassadors and other public ministers, judges of the Supreme Court. Again, uses judges, not justices. They are not justices. They are just judges of the Supreme Court. And in general, all officers of the United States established by law. The president of the United States would be an officer elected by the people for 4 years. So Hamilton is trying to make the case, and you're welcome to read this one as well. Really, those first two are the ones pertaining to this topic. Hamilton is trying to make the case, because you get to elect this guy, he's not a king. And because he has to get permission from Congress for every single thing he wants to do, he's not a king, because a king is inviolable. Well, let's see exactly what the Anti-Federalists had to say, since Hamilton is portraying this perfect picture that the U.S. president would never become something like a king, inviolable, and what would be the best word? As irreplaceable. Let's see what the Anti-Federalists had to say in 1878, before the U.S. Constitution was ever ratified. 74, Anti-Federalist Paper 74, titled "The President as Military King." Uh-oh, I'm sure we can see where this is going. Philadelphiensis, who was influenced by Thomas Paine and common sense, wrote the following selection. It is taken from 3 essays which appearing February 6th and 20th and April 9th of 1788 in either the Freeman's Journal or the North American Intelligencer. He says this: before martial law is declared to be the supreme law of the land, and your character of free citizens be changed to that of the subjects of a military king, which are necessary consequences of the adoption of the proposed Constitution. What did we just hear recently? What did we just have published from the military news? I forget the exact URL. It has been formally now put in place, a formal implementation of policy to automatically register every able-bodied male or every of-age male through the selective service system to be draft eligible for the draft. So what does that make you as a male citizen between the ages of 18 and 25? Well, according to the new policy, 42, because now the age of enlistment is 42. What does that do? If the president so chooses, not through a constitutional means, by the way, the selective service system, unconstitutional, the draft, unconstitutional. We've already gone over this in a previous lecture regarding the draft. What does that do? Are you still a citizen with endowed rights to life, liberty, and property? No. Now you're subject to whatever the whims of the president are, because the president can call a draft and declare martial law whenever he so pleases. So let's continue with this Anti-Federalist paper. Let's continue with this almost perfectly prophetic prediction. Again, before the U.S. Constitution was ever ratified. Proposed Constitution. Let me admonish you in the name of sacred liberty to make a solemn pause. Permit a free man to address you, and to solicit your attention to a cause wherein yourselves and your posterity are concerned. The sun never shone upon a more important one. It is the cause of freedom of a whole continent, of yourselves and of your fellow men. A conspiracy against the freedom of America, both deep and dangerous, has been formed by an infernal junto of demagogues. Our 13 free commonwealths are to be consolidated into one despotic monarchy. Is not this position obvious? Its evidence is intuitive. Who can deny Who can deny but the President General will be a king to all intents and purposes, and one of the most dangerous kind, too, a king elected to command a standing army. Thus our laws are to be administered by this tyrant, for the whole, or at least the most important part of the executive department, is put in his hands. A quorum of 65 representatives and of 26 senators, with a king at their head, are to possess powers that extend to the lives, the liberties, and property of every citizen of America. This novel system of government, were it possible to establish it, would be a compound of monarchy and aristocracy, the most accursed that ever the world witnessed. About 50, these being a quorum, of the well-born, and a military king with a standing army devoted to his will, are to have an uncontrolled power. There is not a tincture of democracy in the proposed constitution, except the nominal elections of the President General and the illustrious Congress be supposed to have some color of that nature. But this is a mere deception, invented to gull the people into its adoption. Its framers were well aware that some appearance of election ought to be observed, especially in regard to the first Congress, for without such an appearance, there was not the smallest probability of their having it organized and set in operation. But let the wheels of this government be once cleverly set in motion, and I'll answer for it that the people shall not be much troubled with future elections, especially in choosing their king. The standing army will do that business for them. The thoughts of a military officer possessing such powers as the proposed constitution vests in the President General are sufficient to excite in the mind of a free man the most alarming apprehensions, and ought to rouse him to oppose it at all events. Every free man of America ought to hold up this idea to himself, that he has no superior but God and the laws. But this tyrant will be so much his superior that he can at any time he thinks proper order him out in the militia to exercise, and to march when and where he pleases. His officers can wantonly inflict the most disgraceful punishment on a peaceable citizen under pretense of disobedience or the smallest neglect of militia duty. The President General, who is to be our king after this government is established, is vested with powers exceeding those of the most despotic monarch we know of in modern times. What a handsome return have these men, the authors of the Constitution, made to the people of America for their confidence! Through the misconduct of these bold conspirators, we have lost the most glorious opportunity that any country ever had to establish a free system of government. America, under one purely democratical, would be rendered the happiest and most powerful nation in the universe. But under the proposed one, composed of an elective king and a standing army, officered by his sycophants, the starvelings of the Cincinnati, and an aristocratical Congress of the well-born, an iota of happiness, freedom, or national strength cannot exist. What a pitiful figure will these ungrateful men make in history, who, for the hopes of obtaining some lucrative employment, or of receiving a little more homage from the rest of their fellow creatures, framed a system of oppression that must involve in its consequences the misery of their own offspring. Some feeble attempts have been made by the advocates of this system of tyranny to answer the objections made to the smallness of the number of representatives and senators and the improper powers delegated to them. But as far as I recollect, no one has been found bold enough to stand forth in defense of that dangerous and uncontrolled officer, the President General, or more properly, our new king. A few pieces under the signature of an American citizen were published immediately after the Constitution broke the shell, and the Hydra made its way from the dark conclave into the open light. In the first number, the writer, in touching on the president, endeavored to conceal his prerogatives, his immense powers. I skipped a line. His immense powers by representing the King of Great Britain as possessed of many hereditary prerogatives, rights, and powers that he was not possessed of. That is, he shows what he is not, but neglects to show what he really is. But so flimsy and palliative could scarce escape the censure of the most ignorant advocate for such an officer. And since then we hear of no further attempts to prove the necessity of a king being set over the freemen of America. The writer of these essays has clearly proven that the president is a king to all intents and purposes, and at the same time one of the most dangerous kind, too, an elective king, the commander-in-chief of a standing army, etc. And to those add that he has a negative power over the proceedings of both branches of the legislature. And to complete his uncontrolled sway, he is neither restrained nor assisted by a privy council, which is a novelty in government. I challenge the politicians of the whole continent to find in any period of history a monarch more absolute. Philadelphiensis. That's how it's pronounced. Okay, so now that we have the historical understanding of exactly what the executive, at least according to what the founding generation said, was supposed to be, how it was predicted to turn out to be, and what the U.S. Constitution actually provides, is the 25th Amendment really conducive to this process? You can use the 25th Amendment, but like that anti-federalist was saying, because of all the sycophants that are innately, naturally, whether it's Trump, whether it's Biden, whether it's Obama, whether it was Clinton, whether it was Bush, whether it was Lyndon Baines Johnson, it doesn't matter which executive you choose. He is going to be surrounded by the people who are most loyal to him. He is going to be surrounded by sycophants, no matter who it is, no matter how royal. George Washington was even susceptible to this sort of corruption. He appointed Alexander Hamilton. Alexander Hamilton, like he made clear in the Federalist Papers, like he made clear in his other pennings as well, he did not care about the U.S. Constitution. He cared about expanding power, and unfortunately had Washington's ear in doing that. And that was made, or had Washington's ear and convinced Washington into doing unconstitutional acts, such as the Whiskey Rebellion, in which Washington imposed upon Pennsylvanians, 500 Pennsylvanians, an unrepresentative, abusive tax. How ironic. Just a decade or so prior, Washington led an American Revolution about taxation without representation. A decade later, putting his fellow citizens, well, he was Virginian, so I guess his fellow countrymen, fellow U.S. members, I'm not sure what the correct term is there, but he went and put citizens of a state who are members of the U.S. to gunpoint because they refused to comply with an unconstitutional, abusive, unrepresentative tax. So no matter how pure the man, no matter how pure the executive, he is going to be surrounded by sycophants. So this is not an exclusive problem with Trump. This is a problem that is embedded into the executive on purpose, as made clear in this anti-federalist paper. So with the 25th Amendment, could it be used? Sure. But it was designed to replace a president who was assassinated. And that's exactly what it does. Those second sections are formalities. They're essentially a tyrant scraping the crumbs off of his table so that way his subjects believe they're being fed while he's chowing down on the loaf. That's what those other sections about the chief officers of the department heads or so on and so forth submitting letters and declarations. It's not going to happen. Can it happen? Sure. Is it going to happen? No. So how do we go about fixing this problem? I'm not one to just display the problem and then not offer solutions. There are a number of solutions, so don't feel helpless. What you will have to feel is discipline and the willpower to do the necessary resolve or the necessary resolutions. And we have 3 or 4 of them. So the first one being is one that is heavily dependent on the military upholding their oaths of enlistment, which require, whether it's enlistment or a non-commissioned officer, any agent of the U.S. military forces is required upon joining the U.S. military to take an oath. That oath requires, so help them God, to preserve, defend, and protect the United States Constitution against enemies, foreign and domestic. And part of that U.S. Constitution, it does not include in Article 2 the power of the executive to go and commit these unilateral acts of war. And that's exactly what they are. They're not military operations. They're not offenses. They are acts of war. So in order to uphold the U.S. Constitution, in order for these military members to uphold their oaths, which are binding on their very lives, they are putting their name, their word, their soul, so help me God. That's part of their oath. Making a promise to the U.S. Constitution. Not even the citizens of the state, not the president himself, not the U.S. Congress, not the U.S. Supreme Court. Making a promise to the U.S. Constitution to uphold it against all enemies, foreign and domestic. And because Article 2 to the U.S. Constitution does not grant the power of war, declaring war, or conducting any sort of war acts to the unilateral beliefs of the president, any time that is enacted by a president, the military, according to their oaths, has to disobey those orders, has to disobey the requirements, the demands, the commands, whatever name you want to give it, of that executive and any officer who is carrying out those orders. So now, for this resolution, we're going to get to the other 3 or so resolutions here in a minute. I want to dive into the Uniform Code of Military Justice because I know I'm already stoking up fears for all of you Marines, sailors, soldiers, airmen, guardsmen, whichever branch you're in. Well, Caleb, if that happens, I could very well be disappeared. I could very well be court-martialed and have my life put on the line because one of the punishments for disobeying lawful orders is death, is possible death. So don't take my word for it. Go and read through the US or the UCMJ. If you don't feel confident reading through it yourself, I would discourage you because many of the officers, many of the judge advocate general officers are going to be in cahoots with the other officers and the current executive. But if you have a friend, if you have a buddy, someone you can trust who is a JAG officer, and you don't trust yourself to read through this document alone, then of course go ahead and consult with him. Or if you have questions about what's said in the UCMJ, go ahead and post them down in the comments. This is to help you. Remember, your oath is to the U.S. Constitution, not to any JAG officer, not to military judge, not to any military judge, not to the president, Congress, judiciary, whatever. So I'm going to show you here. UCMJ, now this is the 2024 edition. The 2025 edition and 2026 edition show similar provisions, if not identical provisions. Let's go ahead and scroll down to, I've got my notes here about which page we need to go to. We're going to scroll down to 334, page 334 of this PDF, which discusses Article 90, 10 USC 890, titled Willfully Disobeying Superior Commissioned Officer. It says here, text of statute, any person subject to this chapter who willfully disobeys a lawful command of that person's superior commissioned officer shall be punished. 1, if the offense is committed in time of war, by death, or such other punishment as a court-martial may direct. And 2, if the offense is committed at any other time by such punishment other than death as a court-martial may direct. Further down, inference of lawfulness. An order requiring the performance of a military duty or act may be inferred to be lawful, and it is disobeyed at the peril of the subordinate. So not only is the JAG officer and the military judge and the executive likely going to be in cahoots with making sure you comply, but you're also, when you enter that military courtroom, that court-martial, you are the one with the burden of proof. You are not presumed innocent. You are the one presumably having already committed a criminal act. This inference does not apply to a patently illegal order, such as one that directs the commission of a crime. Authority of issuing officer. The commissioned officer issuing the order must have authority to give such an order. Authorization may be based on law, regulation, custom of the service, or applicable order to direct, coordinate, or control the duties, activities, health, welfare, morale, or discipline of the accused. There's another standard that's required of a lawful order that they didn't list there, but I'm going to show you where in the UCMJ that standard that you can use in your defiance, that you can use in your upholding your oath, rather than disobedience or defiance, in your defense. 4, relationship to military duty. The order must relate to military duty, which includes all activities reasonably necessary to accomplish a military mission or safeguard or promote the morale, discipline, and usefulness of members of a command, and directly connected with the maintenance of good service and of good order in the service. Good grief, I have to untie my tongue. The order may not, without such a valid military purpose, interfere with private rights or personal affairs. However, the dictates of a person's conscience, religion, or personal philosophy cannot justify or excuse the disobedience of an otherwise lawful order. Disobedience of an order which has for its sole object the attainment of some private end, or which is given for the sole purpose of increasing the penalty for an offense which it is expected the accused may commit, is not punishable under this article. 5, relationship to statutory or constitutional rights. The order must not conflict with the statutory or constitutional rights of the person receiving the order. So there we get that implied standard that is going to be made overtly clear in Article 92. So here's Article 91, 10 USC 891, insubordinate conduct toward warrant officer, non-commissioned officer, or petty officer. A, text statute. Any warrant officer or enlisted member who 1, strikes or assaults a warrant officer, non-commissioned officer, or petty officer while that officer is in the execution of his office. 2, willfully disobeys the lawful order, notice it doesn't say unlawful order or just any order, it says the order has to be lawful. Willfully disobeys the lawful order of a warrant officer, non-commissioned officer, or petty officer, or 3, treats with contempt or is disrespectful in language or deportment toward a warrant officer, non-commissioned officer, or petty officer while that officer is in the execution of his office, shall be punished as a court-martial may direct. So now let's scroll down to Article 92. And in this section, it is made overtly clear a third standard, or it may have been a fourth, a required standard of an order in order to be lawful. Article 92, 10 U.S.C. 892, failure to obey order or regulation. Any person subject to this chapter who, 1, violates or fails to obey any lawful general order or regulation, 2, having knowledge of any other lawful order issued by a member of the armed forces, which it is his duty to obey, fails to obey the order, or 3, is derelict in the performance of his duties, shall be punished as a court-martial may direct. Here's an important standard that we're going to be applying for this resolve of this conflict, this transgression. The definition of lawfulness. C. A general order or regulation is lawful unless it is contrary to the Constitution, the laws of the United States, or lawful superior orders, or for some other reason is beyond the authority of the official issuing it. See the discussion of lawfulness in subparagraph 16C. Unless the order is contrary to the Constitution. And this second provision is redundant because any law that is binding for the United States, or for these United States, has to first be pursuant to the U.S. Constitution. That's in Article 6 of the U.S. Constitution. So whatever is constitutional, or whatever is to be lawful, also first has to be constitutional. Otherwise, it's not binding. It's not lawful. So what am I saying here? I'll give you a very clear 1 to 2, maybe 2 to 3 statement procedure. The U.S. Constitution does not allow the U.S. president to do what he's doing in Iran. The U.S. Constitution does not give the president to then command the U.S. military forces without permission from Congress to go and act in a manner that supports or buttresses or optimizes the operations taking place, the war acts taking place in Iran. Third, because of what the UCMJ says, because of each military member's oath to uphold the U.S. Constitution against all enemies, foreign and domestic, the orders passed down from the U.S. president, at least in relation to what's taking place in Iran, any orders relating to that are unconstitutional. Therefore, any orders deriving from that action, deriving from that war, which has been now admitted to be a war by the executive and by his subsidiaries, without a formal declaration of war from the U.S. Congress, any actions, any orders that pertain to that operation going on in Iran are unconstitutional, thus are non-binding on you as a U.S. military member. Not only should you refuse those orders, but according to the UCMJ, according to your oath, you have to. Well, Caleb, that puts my life in danger. I understand that. Because a military judge may not see it that way. But that's part of your oath. That's part of joining the U.S. military. Your oath is first and only to the U.S. Constitution, not the president, not even yourself, not the judiciary, not the legislative. It is to the U.S. Constitution. Thereby anything, including orders coming from the executive and any officer passing down those orders, are unconstitutional. And your obedience to those unconstitutional orders would be a violation of your oath. I understand it's daunting. I understand it could be even life-threatening for you. But that was part of that promise you made. So help you God. Whenever you raised your hand and swore an oath to uphold the U.S. Constitution. You do this, or you violate your oath. You disobey any and all orders pertaining to the Iran war, which has not been formally declared by the U.S. Congress, or you violate your oath. Choose. What about for the other modes? What about the other resolutions? Let's say the military is completely in lockstep with whatever the U.S. president wants to do. Well, thankfully, with the Federalist Papers, Federalist Paper 46, written by Mr. James Madison, father of the U.S. Constitution, he actually addresses one of these concerns. Not directly parallel with the president going into foreign nations without getting a formal declaration of war from Congress first, but he does address this idea, well, what happens when the military, despite their oaths, show total obedience and loyalty to the U.S. president, even when the U.S. president's actions, orders, and military ambitions are contrary to the U.S. Constitution. In number 46, The Influence of the State and Federal Governments Compared, again by Mr. Madison, published January 29, 1788, he says down here, the only refuge left for those who prophesy the downfall of the state governments is the visionary supposition that the federal government may previously accumulate a military force for the projects of ambition. According to Madison's other pennings, like the Virginia Resolution of 1798, it seems he was truly naive, truly ignorant, that he honestly, authentically believed that the U.S. government would not go outside of its bounds. Hamilton, on the other hand, shows that he knew exactly what he was doing when he lied about the U.S. Constitution is effectively going to constrain the powers of the executive, legislature, and the judiciary, so on and so forth. And then Jay was, well, he was just an authoritarian. He liked the idea of monarchy. Jay was the third author, by the way, of the Federalist Papers. But Madison shows, in his other pennings as well as these, to have truly been naive and ignorant. He truly believed that the U.S. government would keep to its promise of remaining within the restraints of the U.S. Constitution. But he says this, let a regular army, fully equal to the resources of the country, be formed, and let it be entirely at the devotion of the federal government. Still, it would not be going too far to say that the state governments, with the people on their side, would be able to repel the danger. The highest number to which, according to the best computation, a standing army can be carried in any country does not exceed 1/100th part of the whole number of souls, or 1/25th part of the number able to bear arms. To these would be opposed a militia amounting to near 500,000 of citizens with arms in their hands, officered by men chosen from among themselves, fighting for their common liberties, and united and conducted by governments possessing their affections and confidence. Those who are best acquainted with the last successful resistance of this country against the British arms will be most inclined to deny the possibility of it. Besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached and by which the militia officers are appointed forms a barrier against the enterprises of ambition more insurmountable than any which a simple government of any form can admit of. On summing up the considerations stated in this and the last paper, they seem to amount to the most convincing evidence that the powers proposed to be lodged in the federal government are as little formidable to those reserved to the individual states as they are indispensably necessary to accomplish the purposes of the Union. Is one of those purposes go bomb and invade and coup foreign nations? No. The U.S. Constitution was entirely focused and framed on benefiting the states internally, not going abroad and overthrowing governments and trying to conduct regime change, especially conducting war acts without first getting permission from the U.S. Congress. So what is that to say after reading 46? The point is, even if the U.S. military wants to show total allegiance to the president before their oaths to the U.S. Constitution, the case would be, of course, you don't have to take up arms and we don't have to go and overthrow the military because, frankly, they don't have the capacity to stage an affront against the citizens of the states. But it does mean that when the military shows allegiance to the president before upholding their oaths to the U.S. Constitution, that they are not the determining authority. It's always going to be the citizens. And when we have a clear-cut instance such as this, where the president is going awry, violating the U.S. Constitution, and it's not just Trump, it's every single executive. It's designed, the executive is designed innately, naturally, to cause this, to bring this about. So it's not Trump individually that has this problem. It's been a problem with every president. But when the president goes awry, that it is the duty of the citizens, the duty definitely of the military members, the U.S. military members, to reject the orders, to reject the commands, to not participate in any way, form, metric, measure, financially, boots, individually, collectively, supporting the unconstitutional actions. And that goes into the other two resolves. That being, of course, voting for your congressman to go and conduct impeachment hearings and have a conviction that the president is violating the U.S. Constitution, that he's acting well outside of the confines of Article 2. And the third one, or I guess the fourth one, would be invoke the compelled subsidization doctrine, which says if and when a government acts contrary to the protections guaranteed to you, that whenever they try to go and violate your rights, the promises made to you in something like a constitution, that you have no obligation, no duty to continue funding that government. You have no reason, no obligation to continue funding that government. And given that this is such an irrevocable case, irrevocable instance, that the U.S. executive is acting far outside the confines, and again, I'm going to keep reiterating it because it's not a Trump-specific issue. It's been a problem with every president all the way back to Washington. And to think the Anti-Federalists predicted this to happen in 1787. When the U.S. government goes awry, when the U.S. government acts outside the confines of the U.S. Constitution, whether that be the legislature, the executive, the judiciary, it is incumbent upon the citizens, not of the U.S., but of the states. It is incumbent upon the states to make sure that government and the actions taken by it are completely kneecapped, have zero resources, zero capability to carry out their unconstitutional actions. So there's the 3, maybe 4 remedies. Sure, you can invoke the 25th Amendment, but it's not going to work. It's not designed to work in the manner that the advocates for invoking it are going to try to get. It's not feasible because the president has always been surrounded by sycophants, just as Anti-Federalist Paper 74 said there. More realistically speaking, the resolutions that would bring about the same end, but in an expedient and constitutional fashion, would be 1, if you have children, if you're part of the military, the U.S. military, Marine, Special Forces, sailor, airman, soldier, guardsman, you have a duty. Further, you made a promise, so help you God, to uphold and protect, defend the U.S. Constitution against all enemies, foreign and domestic. That would include unconstitutional orders coming from your commander-in-chief. That's the quickest way to resolve this problem. There has never been a formal declaration of war against Iran, yet the administration has already, after a couple of weeks of denying it, the administration has now acknowledged that it is in fact a war. They are committing war acts.
First regime they led are now dead. Their command and control of the Islamic Revolutionary Guard Corps is being decimated as we speak. Their ability to launch missiles and drones is dramatically curtailed, and their weapons, factories, and rocket launchers are being blown to pieces. Very few of them left. Never in the history of warfare has an enemy suffered such clear and devastating large-scale losses in a matter of weeks. Our enemies are losing in America, as it has been for 5 years under my presidency, is winning, and now winning bigger than ever before. Before discussing this current situation, I also want to thank our troops for the masterful job they did in taking the country of Venezuela in a matter of minutes. That hit was quick, lethal, violent, and respected by everyone all over the world.
A formal declaration from the U.S. Congress has never been announced, has never been ratified against Iran. Therefore, any actions, any operations that support, that optimize the operations taking place in Iran are unconstitutional. Thus, you have not just a duty, you are oath-bound to deny those orders, whether it comes from the executive, whether it comes from the officers. I understand that may put your life in jeopardy. I understand that may get you court-martialed. But that was part of the package whenever you made that oath, so help you God, with God as your witness. That was a requirement. Second, to the citizens of the states, if the U.S. military is going to show total allegiance to the president, you don't have to take up arms, you don't have to get violent. Just know that you are the ultimate determining authority, and that according to the founding generation, you have every ounce of permission to outnumber that oath-breaking, promise-violating standing army. The father of the U.S. Constitution would endorse your resistance. If there is any opinion to consider on this, it would probably be his. Or, better yet, take George Washington, who said any offensive without permission of Congress is illegitimate, is unconstitutional, that he would never imagine taking such a step. Or Thomas Jefferson, author of the U.S. Declaration of Independence, whenever he addressed Congress regarding the Barbary pirates. He took only what was necessary to make a defense and didn't go one step further, because one step further would have been unconstitutional. It is so clear, it is irrefutable, that the actions taken by the current executive, and has been taken by many executives, is unconstitutional. Third, contact your congressman about beginning impeachment hearings. Again, this isn't a Trump-specific problem. This is all executives. And we need to get well acquainted with these processes, because the executive, again, not just Trump, is naturally designed to be like this. So we need to know how to use these tools, how to use these operations and modes, so we can hopefully revive and then sustain a truly free, legitimate Republican form of government. The Republican form of government that's promised to us in Article 4, Section 4 of the U.S. Constitution. And then lastly, it cannot remain as a bluff. Whenever there are times such as these where irrefutably unconstitutional action is being taken by the U.S. government, it is our duty as citizens of states who are members of the U.S. government to hold that U.S. government accountable to its constitutional violations and not participate, not subsidize, not assist in any way, form, fashion, or metric the actions of that government. It is incumbent upon us to invoke the compelled subsidization doctrine. It is required of us to nullify the unconstitutional overreaching powers and actions of the U.S. government. And we have precedent from the president himself. When just not long ago, just a couple months ago, he said we're going to be nullifying the carbon tax that's going to be levied by the United Nations. If the president, if the U.S. government can nullify the actions of a union they're a member of, the United Nations, how does it then follow that the states can't nullify the illegitimate actions of the union they're a part of, that being the United States? So in summary, we have 4 expedient constitutional modes, maybe even 5. Because the 5th one, you could just contact your state representatives, your state legislatures, and tell them, your comptroller, and tell them, don't report anything to the U.S. government. Don't participate in the U.S. government, because right now they are partaking in an unconstitutional, illegitimate war. So realistically, there's maybe 5 or 6 solutions. The 25th Amendment it's not going to work because it was never designed, despite what it says, it was never designed to remove a president as a show of resistance. It was to make up for when a president gets assassinated. That was the purpose. And it says and provides all of these different sections, but because of how the executive is designed, he's going to be surrounded by sycophants who are not going to betray him. So the 25th Amendment, though it can be invoked, it's not going to be effective. First one, military members, you are oath bound to refuse, to deny, to reject any orders that pertain to the Iran war. Second, to the citizens of the states, you outnumber the U.S. military. If the U.S. military shows allegiance to the president before their oath to the U.S. Constitution, you outnumber the U.S. military, according to Madison, 1 to 100 in terms of total population and 1 to 25 in terms of able-bodied men. Third, get in contact with your U.S. congressman, congresswoman, whichever. Tell them to begin discussing ideas of impeachment. And fourth, if those first 3 all fail, you as a citizen have absolutely zero duty, zero obligation to partake, facilitate, subsidize in any form, fashion, or metric the unconstitutional actions of the U.S. government. Invoke the compelled subsidization doctrine, and in the most effective, constitutional, expedient way, kneecap the illegitimate, unconstitutional actions taken by the U.S. government, whether that be the executive, the Congress, or the judiciary. So if you have any questions about what I presented here, maybe you think I'm just totally off my rocker, or maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.